How is child custody decided in Virginia? The guiding standard in child custody and visitation cases is the best interests of the child. Although parents can reach a written agreement and consent on child custody, child visitation, and child support, ultimately a judge could disregard what the parties have agreed to and do what's in the best interest of that child. Now, parents stand on equal footing with respect to each other. I'm often asked, isn't it the case in Virginia that the mother's going to get custody, the father doesn't stand a chance? That's not true, that's not correct. In fact, Virginia used to have what was known as the tender years presumption. This was a presumption that a child of tender years, a very young child, would best be served by being with his mother. So previously in custody disputes, a young child often would be placed with his mother rather than with the father. That presumption has been done away with in Virginia. So mother and father stand on equal footing. Although we no longer have the tender years presumption, as between two equally fit parents, there is a tendency to award physical custody or primary physical custody or have the child reside with the party who has been the primary caretaker of the child. And in many situations, that is the mother. But in fact, the parties do stand on equal footing, and either one of them can prove by a preponderance of the evidence that the best interests of the child would be served by having that child reside with them. Now, the factors that the court can consider in making a custody determination are listed on the whiteboard. There are 10 of them. The first factor is the condition of the child, mental, physical, emotional, taking into account the developmental needs of the child. The second factor to be considered by the court is the mental, physical, emotional condition of the parties, usually the mother and the father. The third factor to be considered by the court is the relationship between the parent and the child. And here's where the primary caretaker again might have an advantage over the party who's been less involved in the child's life up to that point and maybe doesn't have quite as close a relationship. Part of this factor is also the parents' demonstrated ability and willingness to assess the changing needs of the child. So here's where the parties, usually the parents, the husband or the wife's father or mother's awareness of what's best for the child and knowledge of the child and the knowledge of the child's situation can really shed light on that parent being the better custodial parent. The fourth element or factor is the needs of the child. What does this particular child need, and what will this particular child need in the future? The fifth factor is the role that each parent has played in the child's life and the role that that parent will play in the child's life. And again, here we have another factor where if we have two equally fit parents and a child that's doing well, the primary caretaker will have an advantage in a custody dispute. The sixth factor is a very important factor in custody disputes between fit parents, and that is the propensity of each parent to voluntarily and willingly support a relationship and communication and contact with the other parent. The idea behind this is that the best interests of the child are served by having a relationship with both parents. So if one parent is willing to allow the child and maybe even foster a relationship between the other parent and the child, that parent would be a preferred custodial parent over a parent who is not willing to allow the child close communication and contact and to develop a relationship with the other parent. So withholding custody or withholding visitation can be a very important factor in a custody dispute between two parents, one of whom is willing to allow the child to have that relationship with the other parent. The seventh factor is the ability to, and this is related to the last factor, it's the ability to maintain a relationship with the child and the willingness to resolve disputes or cooperate or communicate with the other party. And sometimes when the parties have shown an inability to resolve differences, an inability to communicate, an inability to cooperate, they're setting themselves up or making it more likely for the judge to award primary physical custody to one parent or the other rather than try a shared custody arrangement which would require that the parties communicate, which would require that the parties coordinate their efforts and cooperate with one another. The eighth factor, and this is another one I'm frequently questioned about, is the reasonable preference of the child. First of all, Virginia does not have an age cutoff for a child expressing a preference as to which parent that child would prefer to live with or reside with. Instead, the judge is instructed to assess the reasonable intelligence, maturity, age, experience of the child in making that kind of decision. And so there's no specific age cutoff. It depends on that particular child and whether they can reasonably make such a preference. Certainly now very young children are not capable in all cases from expressing a preference. Now the second question I'm asked, or objection to this process, is the emotional effect on the child or the emotional effect on the parents. These types of expressions of preference are not done in open court. The child's not going to say, I want to live with mom or I want to live with dad. This preference will be expressed in camera, in chambers with the judge, either with counsel or a court reporter or a guardian ad litem there. So the parents will not hear the expression of the preference. And the judge does not necessarily decide the case based on the child's preference. Even a child who's sufficiently mature may not know what's in his or her best interests. Children who are older and the subject of custody disputes, judges are going to be more inclined to go by their express preference, with the idea that if you tell a 16 or a 17-year-old who they're going to live with against their wishes, by then the child has enough independence usually that that may cause trouble, and you may have a child who runs away or has trouble in school and is rebellious, even more so than normal. The ninth factor is a history of any family abuse or abuse in the family between the parent and the child or in the family itself. And the 10th factor is a catch-all, such other factors that the judge may consider necessary and proper in making his or her decision. So those are the factors that the judge is guided by in deciding what's in the best interest of the child, and that's how an original custody hearing will be conducted. Now, once a custody, visitation, and support, once those orders are in place, the judge or the court retains continuing jurisdiction over them and can revisit those matters. Now, parties are not allowed to come back in court and just try to retry something when it's basically the same situation. So for a modification of an existing custody order, there's a two-step process. The first step is the party who's trying to change the situation must first prove that there's been a significant change in circumstances since the last time this was decided. And the second step of that process is that the best interests of the child in light of that change in circumstances justifies a change in the existing custody order. So a party who's trying to change a custody order or a visitation order, that can be done, but they need to go through this two-step process to justify the court even hearing it again, and then to convince the judge that custody should be changed in light of that change in circumstances. You should consult with your Virginia lawyer to discuss the likely prospects in any kind of custody dispute concerning your child or children.